Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have Jed Wallace's amended complaint against Blake Lively filed in Texas court tonight. So we're going to go over that together. It is 100-something pages, but the attachments are the CRD complaint and I think the precursor. So that's a good chunk of those pages. I think there's like 60-some pages of the actual amended complaint. We will be going through it together, but as always, guys, I will do a shorter recap of this filing in the morning. So if you just don't have time to sit through the entire long stream, then I'll have something for you tomorrow. But if you want to stick around and hang out with us, please do. Don't forget to hit the like on this video, by the way. If you can't stick around, it really helps me out. Okay, so I see guys, as we're letting people filter in here before we start to read the document, I see guys complaining about, or not even complaining, just saying they didn't get notifications. It happens to me too, and the reason is apparently you can only get a certain number of notifications within 24 hours. YouTube notifications are notoriously crap. So the thing is, this is now my 5th piece of content today. I had 3 videos, and this is my 2nd live stream. We just got off of a live stream 20 minutes or so ago, where we were reading the motion to quash, or the letter to the judge asking to quash Justin Baldoni's subpoena against Marvel Studios. So that was interesting. And he mentioned the subpoena. Roman, I'm not sure. I have not read through this at all. So I just went downstairs and I did a couple things and I came right back to start this one. So I haven't had time to check, but I'm going to say there probably is. And remember that when Blake Lively filed a motion to dismiss Jed Wallace's initial complaint in this Texas court 3 weeks ago, it was, I believe, she leaked his medical condition that the judge in the New York court had redacted. So that was nice of her. But hey, it's easy, I guess. Nope, that's not what I was going with. Give me 1 second, guys. Sorry, I'm going to fix something here. Okay, what was I saying? Oh, when she spread his health condition. Yeah, no, congratulations on spreading something other than legs. That's great. But, maybe don't spread other people's business, just yours. That'd be great, right? And these are obviously public filings, so whatever comes out in them, I guess, is, pretty much everybody's going to know all the time. So. All right, I have it pulled up here. And when it gets to like case law and stuff like that, we'll skim through some of that. Omar is on his Vlad stream right now, but I don't know if he's going to cover this later. So if he does, he'll cover the legal aspects of this kind of stuff. All right. This is the woman who was just given an award by Time as an influential person. Yes, I believe she purchased it, but I can't prove it. So, all right. I think I have everything pulled up here. Just check. Okay. And Jed's lawyers are like really good writers from what I remember. So hopefully this will be more like a story than a technical legal document. I know that obviously it's not always supposed to be the most interesting thing possible, but it always helps for me to read through it when it is. So let's see. Jed Wallace works from home in the Texas Hill County First Street, a small Texas company he founded and owns. Wallace was described by one of Lively's attorneys as living in the shadows with no online presence and no public profiles. She really does describe him as a recluse. And to be fair, he seems to be a private person. There's no real pictures of him or interviews of him that I could find anywhere. So that ended on the Friday before Christmas, December 20th, 2024, when his privacy was shattered to be replaced by the harsh, and in this case false, defamatory and undeserved glare of the Hollywood spotlight involving 2 of the industry's biggest names, Lively and Justin Baldoni, and the movie they starred in, It Ends With Us. Okay. On that day, and before, Lively provided the press with her 1 3-page form employment complaint filed with the CCRD, naming Wallace and Street as respondents and alleging they had sexually harassed Lively and then retaliated when she reported the harassment, and 2, a 62-page, 203-numbered paragraph draft complaint purportedly attached to the CRD complaint, listing Wallace and Street as defendants regarding 10 claims ranging from sexual harassment to breach of contract, and asserting that the harassment had taken place on the set of the movie and the retaliation occurred in the days leading up to the film's release. Wallace and Street were never on the set of the film or otherwise involved in its production, and their limited and sole involvement in gauging public reaction to the film and its stars occurred after the film's release, not in the days leading up to it. So far, so good. Hill Country in Central Texas. Oh, okay. All right. The filings with the California agency are not available online and only available to the public pursuant to a written request for public information, and yet, that night, at 8:48 p.m. Eastern Time, the day the CRD and draft complaints were filed, a reporter sent Wallace an urgent page-and-a-half email which stated that she had learned that Miss Lively filed a legal complaint against you, alleging sexual harassment, retaliation, among other claims. She described details from the draft complaint, including that the complaint includes extensive private text messages and emails, which include exchanges involving you. She added that court records show that your clients have included Paramount Pictures, an obscure fact not easily uncovered. Megan Twohey is, she's really digging into everyone's life here, it seems like. Or maybe Blake Lively, I guess, just volunteered that information to her. As generous as she is with other people's private information. You know? One sec, guys. Okay. The reporter demanded that we need to hear back from you by tomorrow, Saturday, by noon Eastern. At least as early as 5:26 a.m. Eastern Time the next day, Saturday, which is before noon on most clocks. That's awesome. And obviously, we're talking about the New York Times here, guys. The reporter's newspaper posted the draft complaint, which was only a draft and never filed in any court, on its website under the banner, "Read the Complaint." The document remains on the website today. Lively provided all this information to the reporter and her newspaper. That Saturday, December 21st, 2024, media, including the New York Times, Hollywood Reporter, TMZ, E! News, Variety, Today, CNN, People Magazine, which named Wallace, Fox News, and USA Today all reported on the CRD complaint or the draft complaint, giving prominence to Lively's allegations. The next day, additional media, including at least 3 outlets in Texas, reported on the complaints. The CRD and draft complaints, or the contents thereof, had been shared by Lively with multiple media, although she granted one newspaper exclusive access to thousands of pages of text messages and other documents, which were reviewed by the newspaper, as noted in a lengthy article published within hours of the CRD and draft complaints filing under the headlines, "We Can Bury Anyone Inside a Hollywood Smear Machine." Then, on New Year's Eve 2024, the draft complaint, which had by this time grown into a 93-page, 327-numbered paragraph document, the real complaint, was filed in the United States District Court for the Southern District of New York. But the real complaint, unlike the CRD and the draft complaints, did not include Wallace or Street as defendants or respondents. They have a footnote here. It says, when referring to Lively, we mean to include her agents, including her lawyers, consultants, and husband Ryan Reynolds, and the related entities, including but not limited to Betty Booz. Is it Betty Buzz or Betty Booz? I still don't know. Don't really care. Blake Brown, Aviation Gen, Mint Mobile, and Maximum Effort Productions. Okay. The reason for this omission was certainly known to Lively. There was and is no evidence to support the defamatory statements of and concerning Wallace or Street made in either the CRD or draft complaints, or the press reports republishing her defamatory allegations. They had nothing to do with the production or marketing of the film. They being Wallace and Street, I think. Booze, it is booze, so I said it right? Okay, cool. Oh, Buzz is non-alcoholic and booze is alcoholic. Well, Buzz is non-alcoholic. That doesn't track, does it? All right. This lack of proof explains why, 3 weeks later, Lively sued Wallace in Texas state court to obtain potential evidence of Wallace's alleged involvement in the matter, even retaining one of Wallace's former lawyers. Oh, you bitch. Okay, so she retained one of his former lawyers who had represented Wallace in a matter involving Paramount Pictures to prosecute the Texas lawsuit against him to defend this case and serve as co-counsel with Lively's 5 other lawyers in the New York case. That lawyer filed a lawsuit against Wallace in Hays County, Texas, seeking to take his deposition. Lively represented to the judge under oath that she needed the discovery to understand and evaluate potential claims so that any suit filed by Lively against Wallace is supported by competent witness testimony and evidence. And swearing that without this evidence, any lawsuit against Wallace will be groundless and in bad faith or for harassment or improper purpose under Texas Civil Practice and Remedies Code Section 9.011. As prohibited by Texas Rules of Civil Procedure. In other words, she sought from a Texas judge in Texas evidence from a Texan to support her false claims in the CRD and draft complaints targeting, as to Wallace and Street, Texas residents. And I feel like they have to harp on this because she's trying to get it moved to New York. Okay. One sec, guys. The Texas lawsuit was done purposely, and Lively paid a fee to the Hays County clerk to avail herself of the privilege of conducting activity in the Texas court system, and she listed 10 lawyers. Prather, Gottlieb, Bender, Hudson, you know what? From 3 law firms as her representative contacts for the case. The Texas lawsuit related directly to a claim of claim or defense in this lawsuit that is truth or falsity and fault. As we shall see, Lively purposely turned away from her self-styled investigation into the truth, which is probative of both negligence and actual malice. What happened next is remarkable. Without waiting for the Texas judge to rule, and accordingly without taking Wallace's deposition, Lively dismissed her Texas lawsuit falsely, actually preposterously, claiming to the court that Baldoni's lawyer, in a hearing in the New York case, suggested that she do so. What? Wait, what? And then, without any evidence, and knowing, obviously, that neither Wallace nor Street had sexually harassed her or retaliated against her for publicizing the allegations or breached a contract with her, no such contract exists, she joined Wallace and Street in the New York complaint as defendants, claiming that Wallace and Street relations intentionally violated Miss Lively's rights under the California Fair Employment and Housing Act, acting with malice, oppression, and fraud. Oh my God. It really does sound stupid as hell when they just like lay it all out like that. My God. Oh, hey, how's it going? I know, I saw Cassidy was live earlier and I had to miss it. I was so upset. I was like, oh no, I'm gonna have to watch it back after this. Cassidy O'Connell, I'm sure most of you guys know who that is by now. If not, you definitely should check her out. Okay. She added in the New York case that Wallace and Street acted despicably, maliciously, fraudulently, and oppressively with the wrongful intention of injuring Miss Lively. She branded Wallace as evil, claiming he had no regard for the rights or safety of Lively and others, and intentionally caused her extreme emotional distress. Finally, as if she even knew who this guy was. Finally, she claimed Wallace and Street placed her in a false light, forgetting, perhaps, that neither Texas, which is home for Wallace and Street, nor New York, where Lively lives, recognizes this claim, which is without merit in any event. After this lawsuit, on February 4th, 2025, and after she sued Wallace and Street, February 18th, 2025, in New York, Lively, accompanied by her publicist Leslie Sloan and Jamie Candell, is that how you say it, appeared at South by Southwest in Austin, Texas, where, on information and belief, she made additional false and defamatory remarks of and concerning the plaintiffs. Wait. Specifically, when confronted by a Texas resident who stated that Blake lies and referenced justice for Justin, Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming plaintiffs by, at the very least, implication. Confronted by a Texas resident. Is that Kurtz? They're not talking about Kurtz, are they? Are they talking about Kurtz? Oh shit, they're talking about the girl in here that she... Oh! Okay. I'm getting ahead of myself, guys. Calm down, Lauren. Okay. A Texas resident who stated that Blake lies, and referenced justice for Justin, Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming plaintiffs by, at the very least, implication. On information and belief, while in Austin, Lively made additional defamatory remarks concerning plaintiffs. Discovery will reveal the extent of those statements. God, she just cannot stop herself. Oh my Lord, I thought my mom talked a lot, but this chick is nutty. She can't stop. Just stop lying. All you have to do is stop lying, but if you can't manage that, just shut your little mouth. Like, oh my God. Here we go. During her stay in Texas, Lively also traveled to Waco to visit Chip and Joanna Gaines' hotel, and while there engaged in a confrontation with a young girl who was attempting to take Lively's photograph. On information and belief, Lively made additional defamatory comments about plaintiffs, purposefully availing herself of the Texas forum. Discovery will reveal the extent of those remarks. That's so crazy, man. Oh, Kim's here. What's up, Kim? Yeah, no, this is crazy. Lauren's mom caught a stray. Hey, man, I love my mom, but she's chatty as hell. The benchmark for chatty, it was set pretty high in my youth. So when I say this chick needs to stop talking, I mean she needs to stop talking. All right. On February 5th, 2025, plaintiffs demanded that Lively retract, clarify, or correct defamatory statements made by her. On March 7th, 2025, Lively availed herself of her rights under a Texas law and demanded certain information from plaintiffs under the statute. Plaintiffs complied. As of this filing, Lively has neither retracted, clarified, nor corrected her defamatory statements, even though she knows that plaintiffs had nothing to do with the alleged sexual harassment, and further knows that she may avoid punitive damages for part of the claim if she were to retract, again availing herself of the protection afforded by the Texas law. All conditions precedent to the filing of this suit have been satisfied by plaintiffs. Lively reasonably foresaw that her furious allegations would be republished by the media worldwide, and that this form of hell would be visited upon plaintiffs. It should be noted, never did anything to earn her scorn. Well, okay. But she found her voice, Lauren. Well, somebody should have hit it better because this sucks. What she's doing to all these people sucks ass. So, I wish she hadn't. Okay. Talking about parties here. Let's skim over this because nobody's being added here, it doesn't look like. Yeah. Factual background. Okay. It Ends With Us premiered at the AMC Lincoln Square in New York City on August 6, 2024. Although it was first shown weeks before in Texas at an event, Book Bonanza. Street was first approached on August 7th, 2024, so the following day, by Tag PR about assisting it in social/digital mitigation and remediation regarding Wayfarer Studios. So they made contact the day after the New York premiere, where Justin and his family, I guess, were forced in the basement. Is that right? That was that premiere, right? Okay. On August 9th, just a couple days later, Street began work on the 3-month project by monitoring social media regarding the movie and its 2 stars, but did not publish any information to third parties about the participants or anything else, but rather spotted trends about the public's reaction to the film and its stars and subsequently provided advice to Tag and Wayfarer on those subjects. Plaintiffs had no involvement in the production of or marketing of the film and never interacted with Lively at any time. Lively, however, included plaintiffs in her sexual harassment/retaliation CRD complaint and draft complaint and leaked those documents to the press and other third parties. Lively reasonably foresaw that her defamatory accusations against plaintiffs would be republished, and they were all over the world, including in Texas, causing damage to plaintiffs. The CRD complaint alleged that Wallace and Street engaged in a variety of conduct in violation of California Government Code Section 12940, the FEHA, and Title VII of the Civil Rights Act. The CRD complaint went on to allege that Wallace and Street's conduct includes sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, and aiding and abetting harassment and retaliation, as if they had anything to do with any of that. My God. Sorry, I'm trying to find my... Oh, there we go. Millennial Mom, thank you for the 5. Oh my God, how does Wallace know about all this? The word vomit in Texas, in Waco, and Austin. I'm not sure. We're gonna have to wait. We're gonna have to wait and find out. All right. I got my basement shirt from Shirsty. Oh. Okay. The CRD complaint also asked the reader to please see attached complaint for specific details. This CRD attachment was the draft complaint, which had many indicia, is that how you say that? Indicia? I don't know. I'm going to say indicia. Of a standalone legal complaint. I mean, I know what it means. I just don't know how to pronounce it. Indeed, some media later published the draft complaint under the headline, Read the Complaint. The draft complaint named Wallace and Street as defendants and sought damages for 1, sexual harassment, 2, retaliation, 3, failure to investigate, prevent, or remedy harassment, 4, retaliation, 5, aiding and abetting harassment and retaliation, 6, breach of contract, they never had a contract, 7, intentional infliction of emotional distress, 8, negligence, 9, false light invasion of privacy, and 10, interference with prospective economic advantage. Critically, however, the draft complaint was missing several indispensable components, such as 1, the name of the court, 2, the cause number, 3, the causes of action, 4, the prayer for relief, including a statement of damages, and 5, the signature block for Lively's lawyers, although they were listed on the first page as customary in California but not New York, where the case, minus the plaintiffs, was ultimately filed over a week later. Adding to the confusion, Lively used ambiguous group pleading by lumping plaintiffs into phrases like Wayfarer parties, Wayfarer team, Tag digital team, Baldoni Wayfarer team, respondents, and defendants. That left a reasonable reader with the impression that all causes of actions, severe allegations of sexual harassment and violations of California and federal law, are attributable to all defendants, including plaintiffs and/or respondents. Beyond listing the causes of action on the first page of the draft complaint, Lively makes several specific statements about plaintiffs. First, in paragraph 18, Lively specifically states that plaintiffs are a Texas-based contractor who weaponized a digital army around the country to create, seed, and promote content that appeared to be authentic on social media platforms and internet chat forums. A false statement other than a Texas-based contractor. Oh my God. Guys, the fact that she just refuses to believe that there was organic dislike for the way that she was handling this, the press for this movie, is ridiculous. Okay, people just don't like you. They don't like the way you handled it. People are allowed to voice those concerns or disdains, as rude as people can be, and I know people can be rude, all right? But the thing is, people are allowed to be rude to you when you make false allegations to cover up for your own bad behavior. Assholes are not a protected class in this country, for the last time. All right. Second, the draft complaint identified Mr. Jed Wallace, an independent contractor based in Austin, Texas. who was retained by TAG to perform social media services on behalf of Wayfair and Mr. Baldoni in connection with TAG's engagement. Wallace is an independent contractor, and he is based in Texas near Austin. He was not, however, retained by TAG for any purpose, and it was false to say so. Lauren, did you eat a gummy tonight? Not yet. Not yet. I actually just woke up from a nap before this came out, so no. I feel like that would be a disaster. Okay. On top of the specific statements, the overall gist or sting of the draft complaint was that plaintiffs sexually harassed Lively and retaliated against her in violation of state and federal laws. The gist was and is false. Lively went far beyond merely saying, "These are my allegations." Instead, she or her agents communicated them as standalone facts. Indeed, in the end of the draft complaint, she claimed that she had discovered the full extent of the retaliatory campaign launched by the Wayfair parties. This is at odds with what she later told a Texas judge, that she needed Wallace's deposition to learn about his involvement in the alleged sexual harassment and purported retaliation. I just saw one of you tag me in a tweet. Okay. She also alleged in the draft complaint that Lively sought to set the record straight, to hold the Wayfair parties and associates accountable, and to shine a light on this new form of retaliation. Elsewhere, Lively claims that retaliation is about the risk of her ever revealing the truth, which she claims to be doing in the draft complaint by shining a light and setting the record straight. Lively fully intends this draft complaint, a press release dressed as a not yet fully backed lawsuit. Oh, fully baked, my bad. Speaking of not yet fully baked, hi, to be taken as statements of fact, including about the plaintiffs. And of course, she mistakenly thought that by purportedly attaching it to an administrative filing, she would create a privilege against a defamation action such as this. In any event, noting in the CRD rules require a complaint with such specificity or to attach the incomplete draft complaint, which was totally gratuitous and unnecessary for Lively to obtain a right to sue letter. And some of the asserted claims in the draft complaint were not even within the California agency's jurisdiction. God damn it. This is such a mess. On the same day that the CRD complaint, with the draft complaint purportedly attached, was filed, December 20th, the CRD issued Lively a right to sue letter. The CRD complaint, the draft complaint, and the right to sue letter were not posted online. There was no public filing of these documents on December 20th or at any other time. The only way for a third party to obtain these documents was through a public information request or for the applicant to provide it themselves. Now, guys, as you know, these have been publicly available for a while now, almost 3 months, because Jed Wallace in his initial complaint in this Texas court attached them as exhibits. So we have seen them before. But at the time of the New York Times blowing everything up, nobody had seen that. It wasn't public. Okay. Just Ricardo, thank you for the $2. I'm at work. Hello, lovelies. BL/RR equals vomit faces. Hey, Ricardo, what's going on, man? T-shirts, assholes not a protected class. Oh, I have one. I just got one in the mail. I made one, yeah. I'll have to show it next time. I'm not wearing it right now. The one I'm wearing right now has 2 stick figures, and it says, "I got your back," and then one stick figure is holding the spine of the... you know what? Okay. Neither plaintiffs nor their representatives provided either the CRD complaint or the draft complaint to the media at any time. It is not plausible that news media became aware of the CRD complaint and the draft complaint through the filing and worked through the public information bureaucracy in time to post the draft complaint within hours of its filing, all at the beginning of a holiday weekend. We know, for example, that one reporter had the complaints by at least 5:48 Pacific time on the filing date. Other media piggybacked off that media entity's reporting, referencing that they got from that entity the draft complaint, which by then was on the media company's website. Oh boy. There's a footnote here that says instructions for obtaining a right to sue notice. Okay. The false allegations against Wallace and Street made headlines around the world, according to Elle magazine, which linked to the draft complaint, as did many other media. Not only did Lively or her agents provide the CRD and draft complaints to various media entities for out-of-court republication, either directly or indirectly, but they were relied upon in a videotaped program that one media organization used to promote its upcoming article published on December 21st. I wonder who that was. We know who that was. Yeah. Metadata within the video demonstrates that the video was created prior to December 20th and made use of both the CRD and draft complaints. Despite listing 10 violations of California and federal law and alleging a major social media astroturfing campaign, Lively later admitted she knew of no facts to support the allegations against Wallace or Street. Lively filed her verified petition for Rule 202 deposition in Hays County, Texas, alleging that Wallace was a subcontractor to a company called TAG, and on information and belief, it was to assist them in their unlawful retaliatory social combat campaign against Lively. The Texas lawsuit conceded that Lively has no facts supporting the allegations she made against Wallace and Street in the draft complaint, but that now, apparently under the threat of sanctions from one of plaintiff's attorneys, she sought to investigate the scope of Mr. Wallace's conduct. Lively's verified Texas lawsuit is replete with judicial admissions that 1. Wallace worked remotely from Dripping Springs, Texas. 2. A substantial part of the events giving rise to the claims that Lively seeks to investigate, specifically Mr. Wallace's work on the social manipulation campaign, occurred in Hays County, Texas. And 3. A substantial part of the underlying events that would give rise to the claims against Wallace being investigated occurred in Hays County, and Mr. Wallace resides in Hays County. Right. It also admits that Lively lacked the critical evidence relevant to petitioner's potential claims, the specifics of the conduct by Mr. Wallace. Okay. So that is why she was bringing the Texas lawsuit, for the discrete and specific purpose to investigate the nature and scope of Mr. Wallace's work. The very thing she had already leaked to the press as factual assertions. On top of admitting that she did not have the factual and evidentiary basis for the claims against plaintiffs, Lively knew that her timeline did not add up. Lively's very clear that she believes plaintiffs were hired no earlier than August 8th, 2024. They were actually approached on August 7th, but did not begin work until the 9th, and that even TAG was not engaged until August. But her own draft complaint shows negative sentiment towards her building in July. This fact alone should have put Lively on notice that her accusations were false, or at the least she was negligent for not inquiring. That is true. That's so very stupid. I mean, come on. And it makes sense that she would lack that evidentiary and factual basis, that she would lack the critical evidence and the specifics of the conduct by Mr. Wallace. Lively knew that plaintiffs had not harassed her, and she had no evidence that they retaliated or were guilty of any of her other claims. Again, in the draft complaint, Lively paints a nefarious picture that Wallace, as an employee of Street, participated in an astroturfing campaign that published false and negative statements about her or boosted comments that did so. But that's not what Wallace did. One second. Bear with me, I've been sick for a couple days. No cotton mouth, just a sinus stuff. Sorry. Okay. Again, in the draft complaint, Lively paints a nefarious picture that Wallace, as an employee of Street, participated in an astroturfing campaign that published false and negative statements about her or boosted comments that did so, but that's not what Wallace did. Wallace's job was to read, analyze, and assess all forms of media and trends taking place with respect to various issues. Wallace did this limited role as an employee of Street, and all these tasks were performed in Texas. This job was in line with Wallace's work generally with respect to all forms of media. Specifically, for the events related to Mr. Baldoni, Wallace's limited job was to conduct analysis of all forms of media, analyze the sentiment of the coverage, and then provide updates on the observations. After passively observing the social media environment, Wallace saw an organic outpouring of support for Baldoni in the film. Wallace's feeling, based on what he saw, was that no remedial actions needed to be taken at that time, and that everyone should let the sentiment on social media unfold organically. In addition to observing that people on social media organically supported Mr. Baldoni, there appeared to be a dislike for Miss Lively based on her tone-deaf promotion of the film. Which, let's be honest, if she had just managed to give that speech where she used her mother as a prop during the PR for this film instead of at her, Time Gala or whatever last night, this may not be happening right now. I would just be downstairs playing Pokemon, not talking to any of you. All right. Therefore, Wallace's advice was not to do anything at that time and let the sentiment on social media continue to unfold organically. So basically, just don't defend her honor because people just don't like her. That's how it went. Okay. Because that rule was strictly passive, both the specific assertions in the draft complaints as well as its general thrust and gist are false. Plaintiffs never published, directly or indirectly, any information or content, negative or otherwise, regarding Lively. Plaintiffs never seeded or promoted content that appeared to be authentic on social media platforms and internet chat forums about It Ends With Us, Wayfair, Baldoni, Lively, Reynolds, or any of Lively or Reynolds' businesses or family. Plaintiffs have never asked or directed anyone to post about, comment on, or like any social media posts about, same as above. That makes each of the specific statements made in the draft complaint untrue. And taken together, Lively's gist or thrust of her draft complaint was untrue. The statements of fact, actual or implied, of and concerning plaintiffs in the draft complaint are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and special damages through emotional harm, Wallace, actual damages and real and projected loss of business, Wallace and Street, in an amount that exceeds $1 million. Specifically, Wallace & Street's business model primarily relies on anonymity, not to post negative social media or to weaponize a digital army for an untraceable digital social manipulation campaign, as Lively alleges, but to help ordinary people, and some famous, to receive treatment from a variety of attacks, some physical. In addition, plaintiffs help some people and their families with their addictions by providing health plans and support. The false allegations of fact made with actual malice has meant that Wallace & Street have lost business. Worse than the economic toll is the assault on Wallace's emotional condition. Lively has blasted out in court filings. Here it is. Lively has blasted out in court filings, in this case, confidential health information about Wallace, despite this information being sealed in the New York case and in a redacted declaration and in letters marked confidential. Wallace has suffered medical issues induced by Lively's actions. Wallace's stress began on December 20th when plaintiff's world was turned upside down from the maliciously leaked CRD complaint and the draft complaint, which made totally false and fabricated allegations against plaintiffs. Such physical manifestations are the strongest evidence of mental anguish damages. This factual statement section incorporates all the factual allegations to the introduction section of this amended complaint. All right, so we have jurisdiction and venue, and they're going to talk about the Texas being the appropriate, jurisdiction here. Let's see. This court may exercise personal jurisdiction over Lively because she purposely availed herself of the forum by filing the Texas lawsuit. The defamation claims here have a nexus to the Texas lawsuit because its filing and dismissal will demonstrate in part the fault element of the claim, that is negligence and actual malice. The Texas lawsuit dismissal demonstrates a purposeful avoidance of the truth, which has been, in appropriate cases, held to be evidence of actual malice and certainly negligence. The Texas lawsuit also relates to the truth or falsity of the defamatory allegations because Lively admits she has no evidence that they are true. God, she really screwed herself with these lawsuits. In addition, her defamatory statements were aimed at Texas, where both plaintiffs reside, and they undoubtedly caused harm in Texas. 2 mentions of Wallace in the draft complaint specifically state he's based in Texas. In addition, Lively frequently visits Texas and did so in connection with promotion of the film, including at the Texas Book Bonanza, where she appeared with the Texas author of the book the film was based on, Colleen Hoover, and her other co-star besides Baldoni, Brandon Sklenar. A news report of the appearance contained the following. Right. And it says here, this article is from June 15th, 2024. It says, Blake Lively is the epitome of chic in a fitted floral mini dress as she attends the Book Bonanza event for It Ends With Us in Texas. Epitome of chic in a fitted floral mini dress is like everything that's the bane of my existence. I'm sorry. I'm sitting here in like the same pants in a different color and a shirt with stick figures on it. All right. During the appearance, she spoke to hundreds of people as depicted here. And they're taking a selfie with the crowd there. I'm about to sneeze, guys. Give me a sec. I can't avoid it. It's happening. I shouldn't have said it out loud. No, it's not going to happen. All right. Whatever. Also, during Lively's multi-day appearances in Texas, she promoted the film. Discovery will reveal whether she made any additional defamatory remarks about plaintiffs during these appearances. She did, however, attempt to leverage her brand of sparkling drinks, Betty Booze, with an ad campaign, It Ends With Booze, playing off the film. Oh my God. Her take line for the drink was, every person with a mouth should drink this drink. Yeah, I didn't even see that before. I didn't realize that. That is, honey. Oh no. If I had seen that before, like when all the press, the PR for this film was going on, I would have been cringing. All right. And published a map with 43 locations between Waco and Austin where Betty Booze could be purchased. Oh my God. Lively purposely availed herself of the Texas forum by suing Wallace there. Her defamatory accusations were directed at their conduct in Texas, and all of the damage suffered by plaintiffs occurred in Texas. Furthermore, on information and belief, additional defamatory statements about plaintiffs were made by Lively at South by Southwest in Austin, Texas, and later in Waco. And these formed the basis, in part, of this suit. I think Blake made a pass. Wait, what? All right. Venue is proper because, as Lively alleges in her Rule 202 petition, a substantial part of the underlying events that would give rise to the claims being investigated occurred in Hays County. Okay. Her out-of-court publication of the CRD and draft complaints were directly published by her to the press, and to the extent they weren't, she could reasonably foresee that they would be republished around the world, but specifically in Texas. Finally, she made additional repeated defamatory comments in Texas during an appearance, which occurred at least after this lawsuit. Oh my God. Okay. First cause of action is defamation and defamation per se. Let me see if it has any information about what was said in Waco. I don't think it does, though. Well, the defendant's publications, including identical or similar statements that she made in Austin, Texas, and, upon information and belief, Austin and Waco, caused plaintiffs damage. Defendant was at fault in publishing the defamatory statements because she did not act as a reasonably prudent publisher. That is, she was negligent as evidenced by her withdrawal of the Texas lawsuit, which would have revealed the truth. Oh my God. Okay. Although Lively is a public figure, Wallace and Street are not. Thus, plaintiffs need prove only negligence to establish liability. However, plaintiffs also seek punitive damages in an amount of not less than $6 million. And to satisfy the evidentiary burden in establishing the right to such damages, they must demonstrate actual malice, that Lively either knew the allegations were false at the time she made them, or she acted in reckless disregard of the truth. That is, she had a high degree of awareness of falsity and, in fact, entertained serious doubt about their truth. She acted with actual malice because she was the one claiming to have been harassed and retaliated against. She was the one who claimed she had a contract with plaintiffs, and yet there is no such contract. And plaintiffs were nowhere near where the alleged harassment/retaliation took place. The defamatory statements are per se because they accuse plaintiffs of conduct which is criminal. In addition, the defamatory statements injure plaintiffs in their office, profession, or occupation and are thus per se. That is, damages are presumed and plaintiffs are entitled at least to nominal damages, and the damage case may get to the jury without any proof of damage. All of the statements of facts from the previous sections are incorporated in this section by reference. Okay. 6, conclusion. So we're at the pretty close to the end of this part here. Sadly for plaintiffs, they find themselves in the middle of this coast-to-coast ginormous ginormous. I don't think I've ever seen that word written, to be honest. Hollywood litigation between two of America's leading film stars regarding events which plaintiffs had nothing to do with, purportedly occurring during filming of the movie It Ends With Us and thereafter its marketing. The problem for defendant, of course, is that Wallace has never met Lively and certainly never harassed her, was never on the set of the film where the sexual harassment apparently occurred, and could not have investigated, prevented, or remedied the claimed harassment if it occurred because, for one reason, he had no knowledge of it and still doesn't. He certainly had no power to remedy it, as he was not and has never been her or Baldoni's, who he also never met, employer, and did not retaliate against Lively for claiming he, Wallace, or anyone else sexually harassed her. Neither he nor Street ever contracted with her. Plaintiffs therefore respectfully request that this court enter a final judgment and award damages for 1, Wallace's loss of reputation and emotional distress in the amount of at least $1 million, and punitive damages in an amount of at least $6 million, and 2, Street's loss of reputation in an amount not less than $1 million, and punitive damages in the amount of at least $6 million. 3, court costs, and for such further relief at law or in equity as to which plaintiffs may be entitled. All right. Let's see what we got here. Exhibit 1 is the, is this the right to sue? Yes, this is the right to sue. Okay. I don't think there's going to be anything new in the exhibits here. Here is the complaint of employment discrimination. Okay. And exhibit 2 here is the precursor, I believe. Or no, it's the complaint. Okay. Yeah, so this is just Blake's initial complaint, I'm pretty sure. Or it might be the amended one, but I'm not positive. I don't think there's anything after that. Exhibit B. What is this? Oh, no, this was the... Okay, this is part of her complaint. That's why. Yeah, this is still part of her complaint. So this is just everything we've seen in her filings before. So nothing really new. All right. Well, that's... I'm interested to hear what happened in Waco that they are referring to. Because I'm not really positive, obviously, but... I mean, that was pretty interesting. I feel like his lawyers are good writers. I like reading their stuff. It's not like too technical and boring. And I know that they're not writing this for the layperson, but it is layperson friendly in my opinion. So yeah. Ain't no settling for Justin's team. That ain't a word they know. I don't know if Wallace and Street would settle this Texas case. Irrelevant Photon says, is this the incident in Waco, that woman who was at the same hotel as Blake? Yes. They referred to that above in the complaints, as well as it seems like they were referring to Colonel Kurtz in there as well, but I'm not positive. Mandalane says, did you already go over the Marvel letter? Yes, we did that right before this stream, so you can go to the live stream tab on my channel and find that there if you want. Let's see. Who is... still streaming, so we can send you over to there. One sec, let me find out. I don't know if Cassidy's still on or not. Oh, my friend Ari's on. Hang on. I'm going to send you over to her because she... Okay, so this is my friend. She does not have a lot of viewers right now, but because she's kind of new at this. But if you could go over there, tell her that Lauren sent you and send her lots of bacons, I'm sure that would like make her freaking day. So why don't we do that? Hang on. Don't forget to hit the like button, guys, on your way out. Let me just do this. If I can find it on this list. God, what is happening here? Sorry, guys. Give me one sec. I think she probably has it set up so that you can't. Yeah, she does. She doesn't have redirect privileges. Okay. Well, so we'll send you over to Omar, but if you want, because he's doing Flad right now, but if you want to say hi to Ari for me, I'm going to put the link right here in the chat, guys. Go over there and tell her I sent you. I'm posting it in the chat right here. Hang on. And I should be done for the night. Like I said, I'll have a shorter recap of this out tomorrow. So there's Ari's. She's talking about Blake's speech over on her channel right now. Okay. I think I got through all the super chats and all that. So yeah. We'll do something members only this weekend. I'm going to say probably Sunday because tomorrow I'm probably not going to do too much. But thank you guys for joining me tonight. If anything else pops up for some reason, I obviously will be back. But let's assume for now that I'm going to have a little bit of time to do nothing. So, and I hope nothing else comes out tonight because I will be taking that edible now. And it will be a disaster if I try to come back on. Okay. Anyways, bye guys. I'll see you later.